Good evening. It's nice to meet you.
Good
And
evening, sir.
I'm happy to meet you online on a very important topic. We have taken up this topic for practical reasons. We don't want to go from section 1, 2, 3, 4 like that. This was decided because in day to day life, when we are faced with situations involving offenses committed either against somebody whom we know or within our locality, we are faced with a dilemma. So, to understand the differences, because at present we are following the 1973 Code of Criminal Procedure, and in due course, probably by the end of this year, the 2023 Criminal Procedure Code will come into force. Because, as you know, the 2023 Code under section 1 3, it will come into force from the date the central government by net notification appoint. So, though the bill has been passed and the president has given his assent, and it has been published in the official gazette by the central government, it is not in force yet. So there seems to be some confusion. Questions are being asked. I don't know why people who are well versed in law should be confused or should ask such questions. It is very clearly said in section 1, clause 3, it shall come into force on such date as the central government may, by notification in the official gazette, appoint. So the 2023 CRPC uh, is yet to be enforced. It is yet to come into force. But before it comes into force, it requires uh, a complete restructuring of our criminal justice system. We don't have the sufficient infrastructure at the moment, training also, and the knowledge of the present laws, the 2023 laws. So we are concerned about the last part, namely gaining an understanding of the uh, 2023 CRPC, the provisions of the 2023 CRPC. So I'm very glad that we have lawyers, uh, law teachers, and students, law students, uh, in this online meet. And let us now begin by examining the 1973 CRPC relating to FIR, because this is the first step or the first interaction between the victim and the police, or between persons who lodge a complaint regarding the commission of an offense with the police. Because normally uh, we have to approach the police in case of any harm or injury to you, or if any offense is committed against you or against anybody. So we cannot take the law into our own hands. We have to necessarily approach the police. So we should know what is what. We should understand, we should know uh, what we should do. So it is based on this practical thinking that we are starting this series of interaction about the new criminal laws with FIR. So all of you know, under the 1973, I don't want to call it as the old CRPC and the newer CRPC, new CPC. I just want to differentiate between the year. So the 1973 CRPC, as you all know, FIR is or information about a cognizable offense is covered under section 154(1). So if you have information relating to the commission of an offense, a cognizable offense, you know the classification, cognizable and non-cognizable. So if you have information relating to the commission of a cognizable offense, you can either give it in orally or in writing to the station house officer or the police officer in charge of a station. And if it is given orally, it is reduced into writing either by him or under his direction. And after reading over to the informant, so this is very important, reading over to the informant. So the person need not necessarily be a victim. The principle behind this is that any person can set the criminal law in motion, and that law is set into motion as far as cognizable offences are concerned by giving information to the police. So after having read over to the informant, and after every such information, whether given in writing or reduced in writing, shall be signed by the person giving it, and that is called the first information. It is called the FIR, which we popularly use the term FIR, and it is entered in a book, okay, that is maintained by the police, and a copy of that FIR recorded under subsection 1 of section 54 is furnished free of cost to the informant. This is the present 1973 Act. And of course, it also provides, in case if the police officer refuses to record the information relating to a cognizable offense, the commission of a cognizable offense, the alternative, the next step is also provided in clause 3. The person aggrieved by the refusal can give a writing, in writing, the substance of the information to and send it by post to the superintendent of police having jurisdiction, and if the superintendent of police is satisfied that the information discloses the commission of a cognizable offenses, he can either take it up for investigation by himself, or he can direct any other police officer to do the investigation, and the investigation is done in the manner provided by the court. So this is what the present 1973 CRPC provides. Now we will go to the 2023. So for the purpose of record, the 2023 Act, quite a tongue twister for me. I might be having some difficulty in pronouncing the heading. Uh, it is known as the Bharatiya Nagarik Suraksha Sanhita 2023. My pronunciation may be bad because it is quite a tongue twister for me. I hope you are able to pronounce it as it should be pronounced. I'm yet to come across somebody with the correct pronunciation, but for official purposes, it is known as the Bharatiya Nagarik Suraksha Sanhita 2023, an act to consolidate and amend the law relating to criminal procedure. So, please note that it is an act to consolidate and amend the law relating to criminal procedure. See, as we discuss, we may come across certain inconsistencies, certain difficulties, and even contradictions. So please take note of all that so that we can try to discuss and understand the present 2023 Act CRPC before it comes into effect. So under the new 2023 Act, the subject matter of our discussion, that is FIR, is covered under Chapter 13. Under the 1973 Act, it is covered under Chapter 12. In the new 2023 Act, it is covered under Chapter 13. The heading is the same: information to the police and their powers to investigate. And it is section 173. In the 2023 Act, it is section 173. So under the 2023 Act, every information relating to the commission of an offense, cognizable offense. So 173 clause 1 says every information relating to the commission of a cognizable offense can be given orally or by electronic communication. This is something new. They have added that you can also give the information through an electronic communication to an officer in charge of a police station. The most important addition is that the information relating to the commission of a cognizable offense, irrespective of the area where the offense is committed, that is the most important thing. Uh, I am not going to, at this stage, I am not going to critically examine the use of these words at this stage, but in course of time we will see what is the impact of these words. Normally, under the 1973 Act, information has to be given to the jurisdictional police. All right. Then slowly we found that it does not work in all cases. It's not convenient in all cases. For example, accident cases, rash and negligent driving, causing death, injury. It is not quite possible to go in search of the uh, correct jurisdictional police. And the first thing is to take the affected or the injured persons to the hospital. And the doctor, as you know by the decisions of the Supreme Court, the doctor is expected to begin his treatment immediately without waiting for such procedural niceties as whether an FIR has been lodged, whether the police has been informed, etc. etc. Immediately, you have to start giving the first aid. That was the direction given by the Supreme Court about 20 years ago. And slowly that got expanded. So, if the information is given to the nearest police station or to the uh, police station which comes first, they can record the information and send it to the correct jurisdictional police subsequently. That is also possible. Now, that is also something which was declared by the Supreme Court, and uh, today, even if you give a complaint or give the information about the commission of a cognizable offense to a police station which may not have jurisdiction, they can send it to the correct jurisdictional police. So that is also there. But here in this case, in the 2023 uh, Act, section 173(1), it is irrespective of the area where the offense is committed. So you can give information relating to the commission of a cognizable offense, irrespective of the area where the offense is committed. It can be given orally or by electronic communication to an officer in charge of a police station. So take for example, you are going to the, you are taking a flight, you are flying out of Chennai, and you have uh, received information about the commission of an offense, uh, say in Marakanam or somewhere on the way. Now, you can give the information uh, to the police station, that is the airport police, if you have the time, or you can take your flight, go to Bangalore, wherever you are going, Bangalore or Delhi, and you can give the information there, irrespective of the area where the offense is committed. So you can give a complaint relating to a cognizable offense which happened in Madurai or Maraganam uh, to a police officer in charge of a station at Delhi. That is the purport of this word, irrespective of the area where the offense is committed. You may have information that the offense was committed at one place. You may not be there in the place where the offense was committed. You may not be physically present in the place where the offense was committed, but you may have information. You might have information about the offense that occurred in a place far away from you, and you can give the information, if it is a cognizable offense, to the police officer in charge of a police station which is nearest to you. This is not explicitly or expressly provided in the 1973 code. So according to me, this is one change that has been introduced in the 2023 CRPC. And the second change is that the information can be given by electronic communication. Now, this definitely is going to give rise to problems of jurisdiction. So maybe in course of time we'll try to understand it in the larger picture in relation to the other provisions. Then, if it is given orally, like in the 1973 Act, the matter is reduced into writing by the officer in charge of the police station or under his direction. It shall be read over to the informant, and it shall be, and every such information, whether given in writing or reduced in writing, it shall be signed by the person giving it. I think there is no difficulty in understanding this. And when you compare it with the 1973 Act, there is no change, there is no difference. Then we will go to the other part, namely by electronic communication, because you can give the information by electronic communication also. So, what happens if you give in an electronic communication? So, that is the next aspect which we have to consider. If it is given by electronic communication, it shall be taken on record by the police officer, and it will be taken on record only after it is signed within 3 days by the person giving it. So, though they are allowing electronic communication as a mode or a method or manner in which you can uh, convey the information relating to a cognizable offense, that electronic communication, it shall be taken on record. It will be considered, it can be become official only taken on record. That is the meaning of taken on record by the police officer on being signed within 3 days by the person giving it. And this is where I have some difficulties in appreciating the procedure. On the one hand, you permit uh, communication of information relating to commission of cognizable offense through electronic medium, through electronic means. But on the other hand, it will be accepted and acted upon only when it is taken on record, which means you have to sign within 3 days. If you are the person giving it, you have to sign it within 3 days. So, the practical convenience of lodging a complaint or providing information relating to the commission of a cognizable offense uh, does not provide for any ease, or it does not simplify things, because you have to go within 3 days and sign it. Only then it will be taken on record. Now, this is where we can probably, in fact, we should, because we have uh, provisions under the Information Technology Act to electronically sign. So, there is, you can send a document with your electronic signature. That is also possible. Uh, so, that can be resorted to, we can make use of that, and you can send it by your signature. You sign the electronic communication can be signed by you by affixing your electronic signature and send it to the police. Maybe that will provide for less complications. It may provide for uh, the ease by which, because what is the use of having something electronically done and then complicated by going and signing it, then only the policeman will act. So the purpose is not achieved if we are going to be held up by such requirements. So probably we may have to use, in course of time, we may have to, each one of us might have to use the Information Technology Act, and as per the steps and procedure provided by it, we may have to get an electronic signature for us. Each one of us there might come a time when we may have to have uh, electronic signatures, because most of the time now, these days, we have uh, under the present Indian Evidence Act, we have section 65B, electronic records. We have records which are now electronic in nature, and there is a procedure for that to be admissible in evidence. So all these will have to be considered and taken into account uh, if you are going to use electronic communication for giving information relating to the commission of a cognizable offense. Um, I only hope that it does not complicate our lives, because technology should be used for simplifying our lives. It should be used for easing our way of life. Uh, but this procedure, which is contemplated under the 2023 Act, uh, I don't know if it is going to make things complicated, then it will become a dead letter. It may not be used by people, it may not be resorted to by people, and we may have to do it in the traditional way. So if it is electronically communicated, it shall be taken on record by him on being signed within 3 days by the person giving it. So these are the two modes by which we can give information regarding the commission of a cognizable offense. And once when the substance of this communication is entered in a book that is kept by in the police station, uh, as prescribed by the state government, it becomes the first information report, FIR. Then the 2023 Act does not stop with that. Unlike the 1973 Act, uh, which stops with section 154, 1, 2, and 3, the 2023 Act goes further. It provides to bring in the what I would say the assimilated experience or knowledge which we have acquired in the past few decades, and it has been incorporated in the uh, 2023 Act. So, what happens if the information relating to the commission of a cognizable offense, if the information is given by a woman against whom an offense is committed, offense under the new or the 2023 Indian Penal Code, because it says if the information is given by the woman against whom an offense is committed or is attempted to be committed under section 64, 65, 66, 67, 68, 69, 70, 71, 74, 75, 76, 77, 78, 79, or 124 of the 2023 Indian Penal Code. The Indian Penal Code, by the way, the new 2023 Act is read as the Bharatiya Nyaya Sanhita 2023. So they have classified under the 2023 Penal Code, they have classified offences, and a new chapter 5 is incorporated, known as offences against women and child, of offences against woman and child. So all the provisions which I read, 64, 65, 66, 64 is 63 is rape, 64 is punishment for rape, then 66 punishment for causing death or resulting in persistent vegetative state of the victim. 67 is sexual intercourse by husband upon his wife during separation. 68 sexual intercourse by a person in authority. 69 is sexual intercourse by employing deceitful means. Then you have 70, which is gang rape. 71 is punishment for repeat offenders. 74 is assault or use of criminal force to women with intent to outrage or modesty. 75 is sexual harassment. 76 is assault or use of criminal force to women with intent to disrobe. 77 is voyeurism. 78 is stalking. 79 is word, gesture, or act intended to insult modesty of a woman. So, like this, all these offenses, the victim is a woman. Therefore, when the information regarding these type of offenses, offenses against women, the woman here is the victim, given by the woman against whom an offense under these sections is committed, has been committed, or attempted. When such an information is given by the victim, because it involves a woman, the information should be recorded by a woman police officer under the proviso to section 173(1) of the 2023 Act. But it does not stop there. You also have recorded by a woman police officer is clear. I am clear at least. Or any woman officer. I don't know why they have put this any woman officer, but if we are to understand it, it is probably because the involving it, since it involves a woman, uh, considering the comfort of the woman victim, the victim who is a woman, she can even disclose or provide this information of a cognizable offense to a woman officer. This woman officer may be uh, any person, any officer, not a police officer. It can be a social welfare officer. It can be a protection officer under the Domestic Violence Act, or it can be persons appointed to do counseling and things like that. So I think that is how we may have to consider or interpret this portion of the proviso. So this is the first proviso to section 173 clause 1. Now the second proviso is uh, it covers or it takes into account victims. I don't understand the way it has been drafted in both the provisos. The first one which I said, as well as the second one which we are going to see, they can use the word victim, but they have not used the word victim. Though victim is defined in the 2023 Act, CRPC. There is a definition in the definition clause, there is a definition for victim. So, in spite of having a definition for victim, the word used is in the second proviso, in the event that the person against whom an offense is committed or attempted to be committed under section 64, 65, 66, 67, all the sections which I read before, is alleged to have been committed or attempted, is temporarily or permanently, mentally or physically disabled. So here it takes into account people who are mentally or physically disabled. The first proviso takes into account women, victims who are women and who are where the offense is committed is against women and child. Like I read those provisions 64, 65, 66. So the same offenses are covered here, but here the victims are physically or mentally disabled, challenged people, mentally or physically challenged, and they can be either temporarily or permanently mentally or physically disabled. So this proviso, the second proviso to 173.1, is an enabling provision that provides the recording of this such information given by such physically or mentally challenged people. It shall be recorded by a police officer at the residence of the uh, person seeking to report such offense. This is something which was there in the 1973 Act also. Uh, so, in cases involving rape and all that by physically challenged people or involving minor children, you can go to the residence or the police officer is required to go to the residence of the person seeking to report such offense at a convenient place of such person's choice in the presence of a social educator, a special educator, or an interpreter. So, this is the procedure provided for recording information relating to a cognizable offense where the victim is a physically or mentally challenged person. How to record that information? So the first thing is it should be at the residence of the person seeking to report at a convenient place of such person's choice. Second thing is should be in the presence of, say for example, if the child or a woman is physically not able to speak, or if the child or the woman is mentally retarded, mentally challenged. So, in such cases, you will find the procedure is it should be in the presence of an interpreter or a special educator. Then the third requirement is that the entire matter should be recorded. The recording of such information should be videographed. So the officer recording the information should record it in a video. So the recording of such information shall be videographed, and the fourth requirement, uh, uh, I will say it first, then we will discuss it. It should the police officer recording such statement uh, shall get the statement of the person recorded by a magistrate under clause A of subsection 6 of section 183 as soon as possible. I don't know what is the value of it, because once when it is videographed, again why you have to go to a magistrate, because section 183 under the sorry, section 183, which sorry, I think I pressed something. Okay. So now you are able to hear me. Can you hear me?
Yes.
Yes. Is it echoing? Okay. You are able to hear?
Yes, sir.
Ah,
Please
okay.
proceed.
Okay. Fine. Fine. I think I press some machine mark, some button. Okay. So this provision, section 183 is under the 2023 Act, relates to recording of confessions and admissions. So recording of confessions and confessional statements, uh, I think should not have been included here, but anyway, it is provided here as a requirement. So the police officer shall get the statement of the person recorded by a magistrate under clause A of subsection 6 of section 183 as soon as possible. This, I think, is complicating life. It is not a hallmark of easy procedure. It is not a simplified procedure. It makes the exercise more complicated. And for recording an information given by a person, a victim who is physically or mentally challenged, in the presence of an interpreter or a special educator, because sometimes the victims are children or women suffering from say like cerebral palsy or something like that, where their um, mental awareness and mental growth uh, is that of a child. She might be the victim, she or he may be about 25 years of age as per birth record, but the development of the brain might be that of a 5-year-old child. Uh, so people with such cerebral palsy come across difficulties, but they can express. It's not that they cannot express. They can express. They can shout. They can cry. They can fight back if somebody is assaulting them or things like that, which is the basic nature of human beings. Anybody comes to attack me, I will definitely defend myself. So that instinct is there even for these kind of people. But that is why you need the presence of a special educator. So the information that is that in the event that the person against whom such offences, that is offences against women and child, are committed or attempted, uh, in that event, it should be recorded by a police officer at the residence of the person making such report or at a convenient place in the presence. You already have the presence of either a special educator or an interpreter, and the recording of that information is videographed. So again, and this is only for recording the information. It is only for recording the FIR. At this stage, making a provision and saying that the police officer shall get the statement of the person recorded by a magistrate under section 183, subsection 6, clause. The punishments are very severe, no doubt, for these offences which we have been discussing. So in cases punishable under section, because the offences are so serious, the punishments are also very serious. It can be 20 years, not less than 20 years, from 20 years to life imprisonment without parole, and as per the 2023 Act, or if it is against a child or a gang rape or against disabled and challenged person, it is death, life imprisonment with fine and death. And the fine amount should necessarily be paid to the victim for the medical expenses and rehabilitation of the victim. So it is very serious. Uh, unlike the 1973 code, which says 357 remained a dead letter for several years, uh, providing compensation to victim, unless the Supreme Court woke up and started clearing the lethargy among the subordinate magistrates, and said that there should be a component in the uh, punishment, compensation or fine should be a component, and that fine, a part of it at least should go as compensation to the victim. But here it is compulsory. Under the new 2023 IPC, it is compulsory. There shall be a fine, and that fine in its entirety should go to the victim, and it should be to such an extent that it should cover the medical expenses and rehabilitation of the victim. So, two things under the 2023 Act is that you should impose a fine. That fine should be given to the victim, and it should be such a fine that it should cover the medical expenses and ensure the rehabilitation of the victim. So it's a serious offense. Serious offense involves a serious punishment, and no doubt about that. But the problem here is we are only at the stage of registering an FIR. So why we should add a burden of getting it recorded as soon as possible by a magistrate? Because under subsection 6 of section 183, you will find in all these cases 64, 65, 66, etc. The magistrate shall record the statement of the person against whom such offence has been committed in the manner specified in subsection 5 as soon as the commission of the offence is brought to the notice of the police, provided that such statement shall, as far as practicable, be recorded by a woman magistrate and in her absence by a male magistrate in the presence of a woman. Provided further that in cases relating to the offences punishable with imprisonment for 10 years or more, or with imprisonment for life or with death, the magistrate shall record the statement of the witness brought before him by the police officer. It goes on like this. But now we are only at the stage of recording the information. FIR. We have not, only because after recording the FIR, the police can go into the investigation. Because the heading itself says first information to the police and their powers to investigate. So, considering this particular burden, it is actually a complication, a burden. You have to find a woman magistrate, or if there is no woman magistrate, you have to get a male magistrate and record it in the presence of a woman, and it should be as soon as possible, because under the law, delay in lodging an FIR can prove fatal to the prosecution case. So, I think considering all this, this particular provision, which requires that it should that the uh, police officer should get the statement recorded by a magistrate. This requirement, I think, is a burden. It's quite onerous. So, this is as far as recording an FIR under the 2023 CRPC. So, I think now we can have, I have given you the outlines, the ingredients of these provisions. So, you can now quickly have a discussion and try to enhance our understanding of the new provisions. There are other sub-clauses also, but we will take it up in the next session. But I think this is time, because we have to close by 6:30. We should have some time to discuss also. So please, we have professors, law students, advocates in our meet. So I am looking forward for some interaction. So please feel free to discuss. We will take some time for discussion. We have Dr. Vijayan from Government Law College, Pondicherry. Then we have Dr. Sharmila from VIT, Chennai. Yes, Vijayan.
Sir, good evening, sir.
Good evening.
Sir, I hope you can hear me.
Yeah, I can hear you.
Yes, sir. Sir, no, the last part now that you were telling about the statement being recorded by a magistrate, I don't think that is part of the recording of information process. That is more of a part of the recording of the evidence or as a part of investigation. It says as soon as possible to make sure that the witness who gives the information or the victim who gives the information need not be brought to the court of law at a later point of time as a witness. So this magistrate who records the statement can be brought as a witness in their place if she is not able to, or if the person is not able to, or to make sure that the statement is recorded and the statement stays as such. Though it is given under the same section, but I don't believe that is part of the recording of the information process. It says
So,
as soon as possible. So after the police record it, they can go for investigation as such. That would be a
so,
supplementary process during investigation.
so what you are suggesting is it can be a substitute for examining the uh,
Victim,
complainant or the
complainant, yes, the victim.
complainant. So
Yeah.
it can be used as a substitute. So the
Yes. So
FIR
this
is
statement,
recorded.
FIR is something. If FIR process, though it is in the same section, I believe that portion where they want the statement of the victim to be recorded by a magistrate is that it is recorded under oath, so it becomes an evidence. It becomes a part of the whole process. So that can be used at a future proceeding if a trial takes place, even if the victim is not available, even if the victim is dead or the victim is killed. We find so many places, or the victim is forced to what do
Recant.
you call it? Say other things,
Recant.
recant, right? Get other things. So this stays as a solid evidence against the accused person, but that is not part of the information recording process. Once the person gives the information, it is recorded by a government police official or by with the help of all those people. The FIR will be registered. The investigation will start. It is not immediately or it is not together. So it will not be a condition precedent for FIR. FIR will be registered. Then this thing will take place. I believe that is how it is worded, if I
Well,
am right.
I don't mind because
Uh,
if that interpretation is accepted, because see, the objective of the provision is that the information relating to a cognizable offense should be recorded and the matter should be investigated without any delay.
yes, definitely.
That is the objective. So
Mm,
if it is to be treated as a substitute,
mm,
subsequently when the matter goes to trial, so you are
mm,
talking about when the matter goes before the magistrate or the sessions judge
mm, yes.
during
Mm,
trial, if the informant in whose name the FIR is recorded, if he is
mm,
not available, then
mm.
the statement recorded by the magistrate will step into the shoes of the informant.
Important. The victim, yes.
Uh, well, I have no problem with that.
Mm,
Now we have to see, there are two sides
yes.
in a crime. One is the side of the
No, no,
victim.
I'm saying
Yeah, yeah,
this will be
yes,
part
yes.
of
I,
investigation. More
I
recording of a
actually,
statement by the magistrate will be
I
yes,
actually appreciate what you're saying. I hope that
yes,
we take it in that sense also,
yes,
because you see, the practical difficulties will arise once when the matter is being implemented. Once when we
definitely.
get into
Mm,
the
mm,
day-to-day base tax. So, uh, but in any criminal system,
mm,
we should always, that is what I always feel, because the
yes,
present 1973, the procedure is loaded in favor of the accused person.
yes, sir.
Victim has no meaningful role to play in the prosecution. Uh,
Yeah.
but in any criminal justice system, there should be a balance between the interest and rights of the victim and the interest and rights of the accused.
Accused.
Okay. Now, see, this difficulty is faced under the French legal system. Uh, just to say a few words about that, what
Yes.
happens under the French legal system is that the investigation or the recording of the information, the gathering of evidence, the investigation is done by a magistrate, what they call it as juge
You the
d'instruction.
yeah. Use the
Okay,
instruction. Yes.
so the belief is that since it is being done by a magistrate, a judicial officer, and not by the police, because police means we have to be very suspicious. We have to take it with a pinch of salt. But if it is being done by a magistrate, then you can't challenge it. It is beyond challenge because you can't accuse the magistrate that you are corrupt, you have recorded and done those things for benefiting somebody else. You can't accuse them of nepotism, corruption, bribery, etc., which can be easily done if it is done by a police officer. So the accused is put in the back foot in such cases. So now in our case, if the magistrate is going to come and say, I have recorded the statement, so I am stepping into the shoes of the complainant, or the informant, then that is loaded against the accused. But anyway, we will be very
We have to
happily,
see. We
yes,
have to
with
see.
the
So
interpretation
because the
which you
entire
have given.
process of this act, sir, they said the I think the Home Minister of India has said that this will come into force. They try to bring it by December 2024 this year
Yes, yes,
because they want the infrastructure to be created because there are so many things have to be done here.
yes,
So
yes, yes.
it will take almost at least a year time for this to actually come into force. Yes, sir. Sir. I
That
believe
is,
by the time they will be able to do that.
but once when it comes into force, we have to be prepared. We have to
Yes,
be
definitely,
fully equipped,
definitely, definitely.
and that is the purpose of this exercise.
Yes,
So,
I
okay,
think
any
that
other
there are
person would
provisions.
like to?
There are provisions which are in the other subsections which are following. Nah, we talked about preliminary inquiry, all those things, and we
Yes,
will
yes.
discuss. If you come
Yeah.
up later, if it comes up later, then we can discuss. Yes, thank you, thank you.
But one thing what I wanted to say is, see, now we are only discovering something. Okay.
Yes.
Now the
Hmm.
whole thing has to be discovered.
Hmm.
Then we have to understand it in the entire context of Evidence Act, IPC, and CRPC, the 2023 acts.
Correct.
So we'll have to look at it with a larger picture at the background. Then only we should be able to appreciate what we have in our hands or criticize what we have in our hands. Anybody else, please?
Sir, good evening, sir. This is Uma.
Yes, good evening, Uma. Very
Sir,
nice to see you.
yes, sir.
She is a professor, assistant professor in Government Law College, Pondicherry. Yeah.
Thank you, sir. Thank you so much, sir. Such a wonderful session. I came to know all the things what is there about FIR in the 2023. To add on to this, sir, as you are saying that this is overload, I mean, loaded for the accused. Sir, it is good. From my perspective, I'm saying, sir, this is good on the part of the government. I mean, whoever has enacted this, because they should be loaded. Then only it will be easy to make them. I mean, get them punished. That's my personal perspective for this, sir.
Okay, that's very nice, Uma. Thank you very much.
Sir, may I
Good
step in?
questions.
Sir, may I step in for one
Yeah,
minute? Sir, Vijay, say again.
yeah, please.
Sir, students are I usually ask this. So why is the criminal so loaded in favor of the accused? Right?
See,
And I
actually,
always no, I always tell this is that you know the system. The system is not perfect. It is run by people and policemen. If any day, if you are made as an accused in any case, wouldn't you want these rights to be available to you? Right? Because it is a system where whatever the police right is right in the record, right stays in the record. Whatever they create is part of the evidence. So I always believe that whenever anybody who is an accused person should have these rights, and we don't know who will be put in this position. If you are an accused person, wouldn't you want these rights to be available to you to have a fair justice? Because you are going to fight against the might of the government. It is not any individual. It is not a case between two individuals. It's a case between an individual and the state machinery. So the individual who is handicapped should have more rights. I think should have. It should be. I will not say fully loaded, but they should have a better chance of fighting. That's what I just. No, it is not any count. Just the response that I would give to my students. No, no,
Yeah,
nothing more.
I
Thank
see.
you, sir. Thank
That
you.
is what happened in course of time. That is why I said it should be balanced. We should consider the victim on the one hand and the perpetrator of the accused on the other hand. Uh, the criminal justice system should be balanced. It should not be loaded either in favor of the victims or in favor of the accused. See, take for example, we have come to a stage where the Dowry Prohibition Act, the Domestic Violence Act have become instruments to harass uh, the family. You see, the courts have taken note of that, and now they have said don't mechanically add people. For example, in the domestic violence cases, you add the husband's father, mother, brother, sister, uh, so many people mechanically. So now the Madras High Court has said you can file petition for deleting these people if it is there's nothing on record. See that's a problem. You see, at the implementation stage is where we lack uh, a sense of responsibility, whether it's police or otherwise, because it can be a police case or it can be a private complaint. It's all right. But this is where we don't. And nothing should be done mechanically. Should not do things mechanically. There should be application of mind at every stage because we are dealing with uh, human beings. It can be an accused person or it can be a victim. We have to always think that there is a human being, not one kind of piece of paper in front of us. So we need to have a balanced approach, and that will not come until we change our way of thinking. You see, what we are having now, though it is being claimed that we are throwing away all the colonial system, all old laws, colonial laws. We are having new laws now. Very good, but nothing changes until you change it to our local situation. See, there are places where England is a small country. First of all, you should understand England was a small country, is still a small country. The population is not like our country in those days when the 18th, 19th century England or even 20th century England, the population was very less. So therefore, they had this idea of having CRPC, IPC, Evidence Act, all that. Fine, it might be of good use to them. But now come to our case. Our case, you see, it's a very vast country. India is a very big country, and the population, we are going to cross even the Chinese. Uh, so what we need is not uh, what we actually require is accessibility in matters in cases of offenses being committed. So can you imagine people who are living in far away interior of the village in the countryside? They have to come so many kilometers, travel so many kilometers uh, to the nearest police station. And it is still worse, they have to go to the court system, which is very strange to them. They cannot understand the court system. Can you imagine the mental torture and plight of the victims as well as the accused? Because that is what has to change, which means we need to improve the infrastructure to such a great extent in the sense that it should come down, decentralized, and come down to the level of the village. Only then, I think the criminal justice system will be better placed than the present system. But anyway, I always feel that we should have a balanced system. Easy accessibility to the victims, better safety for the accused, because there is, as you know, every person is presumed to be innocent until proved uh, guilty by without any doubt, beyond reasonable doubt. So that being the yardstick, uh, I to get to that level, we need to come down. We need to reach the village level. We need to come to the village level to sort out, because criminal behavior is not peculiar only to urban people. Criminal behavior is also there with the village people, rural people. So until that is sorted out, I don't know how effective our criminal justice system will be there. Otherwise, people will be going to the court, traveling so many kilometers for years together. Okay. Anybody else, please? Otherwise, we will wind up. Uh, we will continue because our time is limited. We will continue the discussion in 173. So far, we have covered 173, clause 1, with two provisos. Now, we will go later on in the next session. We will interact uh, with the other provisions in 174, 173, and we will see the powers of the police officers to investigate how the 2023 CRPC provides the necessary tools to the police for investigation. And the teaching staff, the who are here in our meet, can add some students of their choice. I think the feedback form is there. You can give your opinion, and we can improvise and make it better. But thank you very much for your patience, for accepting our invitation and attending our meet. And I hope you will continue to participate in our meet in the course of time also. We are planning to have it once a week. So if this time is convenient to all of you, we will have it at this time. Thank you very
Thank you.
much. Thank
Thank
you.
you,
Good
sir.
night.
Thank you, sir. Thank you so much.
Thank you, sir.
Thank you.
Thank you, sir.
Thank you.